if you have a co-parent who is actively trying to co-parent and be more involved, why would you say something like, yo, are you just doing this so modification to child support can happen and you can pay less money? What is going on, everybody? Kevin Parkinson back again. Vinark MP, you are watching Fathers Win. And this is the series on my channel where we take a look at made public court proceedings, family court cases where dads have favorable outcomes. It doesn't happen a lot. A lot of us don't realize how many times us dads go to family court sweating bullets because we know statistically we're going to lose what we're asking for. So this is a really interesting case. This looks like a case of a mom realizing that denial is a river in Africa. And that'll make a lot more sense. So without further ado, hit that subscribe button, like, share, comment. Let's jump right into it. Here we go.
That the referee recommended order be adopted but modified as follows. The mother shall have parenting time every Monday and Tuesday. Father shall have parenting time every Wednesday and Thursday. And the two of you will alternate weekends from Friday after school or 3 p.m. if there's no school until Sunday at 6 p.m. The father's weekend begins February 16th, which is Friday of this week after school, and the mother's weekend begins February 23rd, following weekend. In addition, the parties shall have parenting time at such other times as the two of you can agree. If you reach an agreement on parenting time or holidays outside this order, then they should put that in writing via text or email. The party beginning parenting time shall be in charge of picking up the minor child. The mother shall claim the minor child as a dependent for tax purposes on odd years. Father shall claim the minor child as a dependent for tax purposes on even years. It's good that we address that now than at a later point in time. So thank you, Ms. Sanders, for covering that with the parties. So that is
okay. Everything is looking pretty fair right now. Judge is saying, hey, we're going to modify parenting time. It's going to actually be 50-50. Let's see what happens next.
the recommendation, Mr. Jackson and Ms. Carpenter. So with the court adopting this, you would have joint physical. And actually, this court does not this court does not put out emphasis on joint physical. The reality is joint legal means you share equally any major decision concerning the welfare of your child, such as elective surgery, health. You need to share information. If he goes to the emergency room, you got to notify the other parent immediately. And you need to, if you cannot reach agreement on things like health and education and religion, then the court makes those decisions. And hopefully you can agree upon those. And joint physical means that that person makes the day-to-day decision. So whoever has parenting time, you decide what time your child's going to bed, what he has for dinner, things of that nature. Day-to-day.
So for everybody who's about to go into family court, or you're just not really sure what the judge is saying, he is ultimately creating what is called the parenting plan. Based on whatever state you're in, it might be called something else. Here in Arizona, we call it a parenting plan. The parenting plan is simple. If you and mom cannot agree on something, then the parenting plan is supposed to be ironclad and super duper black and white. The world is super gray. This is supposed to be black and white. This is the time the child goes to bed. This is the time the child goes to school. These are the days that mom has the child, days dad has the child. If you guys have a disagreement, always revert back to the parenting plan. Why it's so important to have a parenting plan? If mom, or in some cases dad, if your co-parent decides to buck up and act crazy, and they don't want to abide by the rules of family court, family law, and do the right thing that their parenting plan says that they have to do according to your family court, the family law practiced in your state, according to custody of your child, and the police are involved, the police are going to come to your house and they're going to say, let me see your parenting plan. A lot of people don't know this part of the game. The police are going to come to your house and they're going to say, let me see your parenting plan. They're literally going to read the parenting plan in front of you, and they're going to be able to say, okay, is this parenting plan valid? Meaning, is it expired, or is this the parenting plan we're agreeing to right now? They're going to ask you, are there any other parenting plans on file? No, officer, this is the parenting plan that we're using. I know this because I've gone through this firsthand. All right, this is the parenting plan that you guys are using. This is valid. The parenting plan says Tuesdays, 4 p.m., your parenting time starts, and it's good until the next morning when you drop the kid off at school. So it's 4:30, mom's not here, and you're showing me an email or a text message on your phone of mom saying, I don't feel like giving you the kid tonight. Guess what? Mom just broke the parenting plan. Mom can be held in contempt. then you can go to court and you can ask for an enforcement of parenting time. Again, this might sound different in whatever state it is that you're living in. That enforcement is going to notify the court, which is going to notify the judge to say a parent attached to this parenting plan or a court-appointed liaison, I was going to say liaison, chaperone, a court-appointed somebody who is over the child. It could be a grandparent. It could be somebody who was awarded custody. Hey, they are or they are not adhering to the parenting plan. Therefore, they're in breach of the parenting plan. Then it's up to the judge to decide what to do. Do I issue a warning? Do I hold you in contempt? Do I reduce your parenting hours? Do I give the other parent more custody, more decision-making rights? These are the things that happen. And because this is ultimately the game or the sandbox in which family court, family law is practiced in, there are a lot of people who abuse these privileges because for the most part, family court isn't criminal court. So if you get in trouble for lying, usually you're not going to jail. But if you're held in contempt, you could. So definitely recommend always get a family plan on paper and adhere to it. Take a look at my other videos where I go over why it's so important to have a family plan, a parenting plan, and why it's important to make sure your parenting plan is fair. Because you could have a co-parent who also tricks you into thinking that your parenting plan is fair, such as something we go over all the time. Let's say you have 50-50 custody, but most of your hours are at night when the kid is asleep or when your child is at school. Technically, based on hours, you have the kid as much as mom does. But you're not seeing the kid that often because when your child is with you, it's in the evening and at nights. And then you take them to school the next morning. You only have like 2 or 3 hours to make sure they eat dinner, do some chores, do their homework, spend some quality time with them, maybe an extracurricular activity, get them in bed, go to school the next day, and then they're gone. A lot of things to consider here. Okay, that's a lot. I know you guys in the comments are like, Kev, stop talking so much. Just play the video. My bad. Out of respect for you guys, I'm going to play the rest of the video without interruption. I'll come back at the end. Here we go.
Decisions. So if the court adopts this, you'll have joint physical and specific parenting time, which is relatively equal, but not week on, week off. So Ms. Carpenter, do you understand the recommendation this morning?
Yeah.
Do you have any objection to the court adopting this recommendation as an order of the court?
No.
Okay. Mr. Jackson, do you understand the recommendation?
Yes.
Do you have any objection to the court adopting the recommendation?
No, sir.
Of course, if circumstances change, either one of you can always petition the court to modify parenting time. As the child gets older and circumstances change, someone moves, you got different employment, you can't be there for the child, someone can always petition to modify parenting time. It's always subject to modification upon a change of circumstances. But the reality is if you want your son to thrive and do well in life, you need to be on the same page. Communication is the key. It's really the key. There's enough challenges in life to make it good for each other and your son. And Ms. Carpenter, you are the mother of a minor child. Do you believe this agreement is in the best interest of your son at this point in time in his life?
I'm a little worried about it, but I'm hoping it will be good.
You're asking the court to adopt the recommendation, correct?
Yes.
All right. The court obviously will take from that. That's addressed the court to adopt the recommendation that you believe at this point in time in his life, it's in his best interest. Do either of you have any questions for the court?
No.
The only question I have, would I have to go on my own and file a motion when it comes to my child support and everything like that, or is that an automatic change? Or
Well, it appears that a child support order was entered $820 per month effective January 1st, 2024. That order has been entered. So
no, right? They told me that it would change once I was able to get physical joint custody and everything was.
Here we go. Moment of truth. Here we go. Come on, Judge. Do the right thing.
Ms. Anderson, I don't know if you can address that. I don't know the recommendation. I don't know what that was based upon. And looks like Mr. Jackson was only given 75 overnights.
Correct. That was based on the judgment of support.
Okay.
So again, if parties are agreement, because again, today was only regarding the objection to the recommendation for custody and parenting time. So if they're agreement, I can put child support be referred to the front of the court. If not, he'll have to file a child support motion.
Do you have time to talk to them this morning and based on their incomes, maybe run it and see what difference it would make? Based
I
on
can do
equal
that.
overnights, it'll make a little bit of difference, Mr. Jackson. Not a significant amount.
And then I also just had another child on the 14th. So I know that kind of factors in also.
Well, again,
Mom mad because he's moving on with his life, but I ain't gonna say that.
perhaps, Ms. Harris, maybe we just add to your recommendation that the issue of child support can we possibly add that to this recommended order this morning? Might be perhaps the best way to address this. All right, so we'll put a sentence in here, Mr. Jackson, Ms. Carpenter, that the issue of child support is referred to the front of the court for investigation recommendation. You both get a copy of the written recommendation. If either of you has an objection, you got to file a written objection within 21 days. If you do not, it'll become an automatic order of the court. If either party objects to it, then it'll come back for his court to make a decision. Obviously, you owe the $820 for the month of January, Mr. Carpenter, so you need to make that payment.
Yeah, no, they take everything out of my checks, and then I paid $855 at the end of January.
Okay. All right. Anything further from either one of you?
Well, now, is that just, are you trying to get all these days so that your child support can be changed? Is that what
This is about my son having me in his life.
Thank you.
Just like,
life using me?
this isn't an argument about money. This is about
No.
my son being around and everything like that.
Thank you.
Right. The court would like to assume that he's not doing this for ulterior motives, Ms. Carpenter.
Thank
But
you.
the reality is yes, there'll be a slight modification, reduction because of the relatively equal overnights. And the court is hoping he's not doing this. And we'll see how active a father he is. Obviously, children are best served if they spend as much time with each parent as possible.
Thank
And
you.
if Mr. Jackson is not exercising parent time, he's leaving it with his mother or his girlfriend, and that's obviously basically to modify parenting time. So we'll get Mr. Jackson to see how he does. If he's going to really invest in this child's life, hopefully will.
He'll do
The court's
great.
going to assume he's got the proper motive for doing this, and time will tell.
Yeah, no, I've always been a big part of my son's life, so this isn't something new or anything like that. I've always been a major part of my son's life.
Okay, well, shout out to the judge for doing the right thing. This is a man who wants to be involved in his child's life. And the audacity of mom, usually in family court proceedings, only when the judge allows you to talk to the judge or a cross-examination, which is usually only in evidentiary hearings, that's when you can say things like how the mom was posing questions. She did a good job of posing what she wanted to say as a question, but ultimately it was a slight to the father. Was how she started her sentence off. So, okay, it's a sentence. It's a question. But then she followed up with some slighting, cutting words. Just doing this so the child support can be modified. And dad did a great job of answering and refuting what she was saying, not getting emotional and not getting mad. There have been times in family court where things like this have happened, and I've been so offended because all I want is to be in my child's life, and I have a co-parent who's doing everything she can to make that not possible or not easy. But that's a trick. Fathers, men, don't get frustrated in situations like this. What this gentleman did was wonderful. He said, no, this isn't about child support. This is about spending more time with my child. And then the judge backed him. And again, the judge is no one's friend. The judge is, if anyone's friend, the children's friend, as they should be, right? But the judge backed the dad ultimately by saying the court is going to believe that the father is requesting this change for the best interest of the child. If you have a co-parent who is actively trying to co-parent and be more involved, why would you say something like, yo, are you just doing this so modification to child support can happen and you can pay less money? Come on, bruh. Well, that's today's episode. Happy New Year. God bless you guys. Make 2025 your best year. If you are a man and you're going through family court, getting ready to go into family court, coming out of family court, I just want you to know this series is for you. Fathers Win on my YouTube channel, Vinark MP. Hit that subscribe button, like, share, comment. Get involved, be a part of this community. We don't hate women over here on Vinark MP. We don't bash women. We are just tired of seeing fathers actively lose in family court. It's time for a change. God bless you guys. Peace.
Whatever. Think I'm supposed to do that.